So we need to talk about a critical decision that happened in a challenge to a state's rifle magazine ban that is now currently up for review again. So let's talk about what is happening. Now, before we jump into this video, I want to tell you about one of the new sponsors and supporters of this channel, which is Home Title Lock. This sponsor can actually save you a lot of time, money, and honestly, a huge legal headache. I'm sure a lot of you are not aware that there is this big wave in a new kind of growing criminal activity that is targeting and stealing home titles without people even knowing. I decided to protect my home and my own home title through Home Title Lock. I've used their dashboard. It's very easy. It shows all the title activity. And really the best part is that if something does ever happen to you, their team over at Home Title Lock will handle the entire legal process and they will restore the title for you so you don't have to go through that headache. So I can't recommend them enough. It's super easy to use. And if you're interested, you can check them out using the link down below in the details section and also in the pinned comment. And right now they're offering you a free 30-day trial and a comprehensive title scan so that you can make sure that your property is actually safe. As I mentioned in the intro, in this video, we need to talk about what is now happening in multiple cases challenging the state of Illinois and their ban on so-called assault weapons and also their magazine bans. Recently, we received a huge decision coming out of the district court there from Judge McGlynn, which struck down the Protect Illinois Communities Act, also known as PICA. This all comes off the heels of a recent Supreme Court order, which denied emergency review in a ton of these cases challenging this Illinois law. And there, the Supreme Court indicated that potentially they wanted a final merits decision. Recently, Judge McGlynn reviewed this case and applied the standards set forth in Bruin and then also the Seventh Circuit's decision in a prior case, Bevis, which is one of these cases that was already reviewed by the Seventh Circuit. And again, he found that the Illinois laws here are in fact unconstitutional and they violate the Second Amendment. However, as we all knew, the state of Illinois was not going to let that stand. So they have appealed this case, all these cases back up to the Seventh Circuit. And once again, they're asking for the Seventh Circuit to uphold this law in the state of Illinois, finding that it does not violate the Second Amendment. The state of Illinois is also asking for the Seventh Circuit to grant a stay against Judge McGlynn's decision so that the rifle magazine ban will essentially remain in effect despite what Judge McGlynn ruled. Now, you might remember that originally in multiple cases, a district court judge there, McGlynn, issued preliminary injunctions that were intended to essentially temporarily halt the enforcement of PICA, essentially until the court could reach a final merits on this case. Judge McGlynn outlined how he believed that the plaintiffs were in fact likely to succeed on the merits of their claims, that this Illinois rifle magazine ban is a violation of the Second Amendment. However, again, the state of Illinois decided to appeal those preliminary injunctions up to the Seventh Circuit, and on review, a liberal and biased three-judge panel in the Seventh Circuit overruled the granting of those preliminary injunctions. Now, coming to that decision, the Seventh Circuit three-judge panel used an analysis that did not align with Heller's common use test or the recent Bruin holding. Instead, the Seventh Circuit concluded that arms protected by the Second Amendment do not include weapons that may be reserved for military use. So they used something known as the military use test, which again is not in line with Supreme Court precedent. So essentially, the Seventh Circuit three-judge panel found that since they believe that AR-15s and these types of magazines that hold more than 10 rounds, since they are useful in military service, the state of Illinois can ban them as dangerous and unusual weapons, and essentially that they are not arms protected by the text of the Second Amendment. Now, in response to those rulings, multiple cases were then seeking en banc panel review in the Seventh Circuit. The Seventh Circuit denied review in those cases, and so that led for a bunch of these cases for the first time to seek immediate Supreme Court intervention on an emergency basis. But as many of you know, the Supreme Court at the end of their last term denied emergency review in these Illinois cases. However, despite those denials, we did get a statement from Justice Thomas. Justice Thomas in those denials in his statement stated that, according to the Seventh Circuit, the rifle selected by millions of Americans for self-defense and other lawful purposes does not even fall within the scope of the arms referred to by the text of the Second Amendment. The Seventh Circuit's decision illustrates why this court must provide more guidance on which weapons the Second Amendment covers. By contorting what little guidance our precedents provide, the Seventh Circuit concluded that the Second Amendment does not protect militaristic weapons. It then tautologically defined a militaristic weapon as those that may be reserved for military use. The Seventh Circuit's contrived non-militaristic limitation on the arms protected by the text of the Second Amendment seems unmoored from both text and history. And even on its own terms, the Seventh Circuit's application of its definition is nonsensical. In my view, the Illinois ban is highly suspect because it broadly prohibits common semi-automatic firearms used for lawful purposes. It is difficult to see how the Seventh Circuit could have concluded that the most widely owned semi-automatic rifles are not arms protected by the Second Amendment. So although the Supreme Court denied review to those cases on an emergency basis, Justice Thomas did state that he has interest in the final merits of this issue. I'm sure other judges on the Supreme Court are also interested, and they also sent a warning to the Seventh Circuit to issue the proper decision. Now, while those preliminary injunction appeals were going on, while those were pending in front of the Supreme Court, the lower court there, the District Court Judge McGlynn, decided to move all these cases towards a final merits decision and to rule on the merits of this issue. Recently, there were oral arguments and a hearing held, and now Judge McGlynn has issued his final decision on the constitutionality of PICA, and he found that PICA is in fact unconstitutional, and therefore he struck it down. However, in that decision, he also stayed the enforcement of his order for 30 days so that the state of Illinois could appeal to the Seventh Circuit. We all knew they were going to appeal, so he gave them 30 days to appeal and then also seek a more permanent stay of his order if they wanted. Of course, Illinois, in fact, did appeal, and now they're seeking a stay of his decision so that essentially the stay will remain in place beyond the 30 days and will be in place during the entire appeal. In their motion, the state of Illinois argues that the district court, for the second time in 2 years, entered an injunction prohibiting the enforcement of Illinois' statute on a statewide basis. The court's decision is badly flawed, and its injunction should be stayed pending appeal. The opinion below fails to faithfully apply this court's decision in Bevis. Indeed, it repeatedly criticizes Bevis. It cannot be squared with the Supreme Court's precedent or the uniform decisions of the courts of appeals applying such precedent, and it would threaten public safety by permitting military-grade weapons to proliferate again in Illinois. So the state's primary argument is that Judge McGlynn misapplied Bruin and then also the Seventh Circuit's precedent and decision in Bevis, and they argue because of that, the decision should be entirely stayed. Illinois walks out public interest, once again arguing that the public will be in so much danger if people are able to buy ARs and magazines, and then essentially that crime and casualties would increase, and because of that, they argue that the public's interest would be served by the decision from Judge McGlynn being stayed, and essentially them still being able to ban rifles and magazines. One of the interesting things with this whole case, this appeal and the stay, is really that Illinois is maintaining a very hardline approach when it comes to these rifles and magazines. They are saying that they are not arms at all covered by the text of the Second Amendment. Even though they are owned and used by millions of people across the United States, the state of Illinois is still arguing that they are not protected arms. They argue in the request that this court held in Bevis that both Supreme Court decisions and historical sources indicate that the arms the Second Amendment is talking about are weapons in common use for self-defense rather than weapons that are exclusively or predominantly useful in military service. Illinois wants to rely solely on the improper military use analysis, which is in the Bevis case, but the lower court demonstrated how the Seventh Circuit decision is not consistent with Bruin and really is at odds with what the Supreme Court said. The district court tried to apply the Bruin analysis more faithfully, but of course the state of Illinois, and now potentially even the Seventh Circuit, doesn't like that because it does not fit their anti-gun agenda. Now, in response to this request for a stay pending the appeal, the Seventh Circuit has now ordered that the appellants here, aka all the 2A organizations representing the various plaintiffs, that they respond to the request, that they file briefs on why the stay should not be granted. And those responses from the 2A organizations are due by November 27th. So that's what's currently going on in the Illinois rifle ban challenges. The Seventh Circuit now has control of these cases once again. And if you were to ask my opinion, I think the Seventh Circuit is going to rule the same way. They're going to come to the anti-gun position that they want. And then eventually probably these cases are going to make their way to the Supreme Court if the Supreme Court does not issue a decision before that in a case like Snope, which is out of Maryland, dealing with the Maryland rifle and magazine bans there as well. So again, very interesting developments in this case. If anything else develops, I will let you guys know. So if you guys like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.